to probate with no will. Now, this might seem odd to you. You might be thinking that probate means there is a will, and you would be right. If there is a will that needs to be administered, there will be a probate. But there could also be a probate when there is no will. Let's say the person did absolutely no estate planning. How is their estate administered after their death? It will be through a probate, but there's no will. So this is called an intestacy probate, meaning no will. How does this work? There's no will. Well, the court will take a look at the people who are involved in the decedent's life, the person who passed, and see who is qualified and who is ready and willing to serve as the executor. And then it's actually called an administrator, but the point is who is in charge of managing the estate. And then what happens is the court will look at who are the heirs at law, which means who are the people who should inherit under the laws of intestacy. And typically what the state will say is, under their laws, is that it is the people who are closest in blood and marriage relations. So is there a spouse? Then that spouse will inherit. Are there children? Then the children may also inherit. In Washington state, if the decedent had only community property, then everything goes to the spouse. But if there is separate property, and if the children are perhaps children from a different marriage, then the children will get some of the property and the spouse will get some of the property. If this is totally confusing, you are right. That is the problem when there is a probate with no will, because there's a lot of facts to be determined, such as who are the heirs at law. Typically that's not the issue, but the property, what kind of property is it, community or separate property, and who will serve as the person in charge of the estate. So there's really no guidance given by the person who died. So the state laws come into play and will direct how the estate will be distributed. When we are handling a probate that's one without a will, intestacy, typically there is more confusion involved because of those reasons. Typically there will be more costs and legal fees involved with it. So one of the best things that anybody could do is make sure they have a will. Make sure that it is clear what they want and where their assets will go, and make sure that whomever they want to inherit will inherit.